Good morning, everybody. Thank you for joining us this morning. We hope that wherever you are joining us from, that you are staying safe and staying well, and all your families are well as well. Thank you for your time this morning while we talk about inward investment into the UK after Brexit. My name is Bethany. I am the Marketing and Business Development Manager at Glaisyers Solicitors. I am here just to introduce our speakers, as they are far more knowledgeable than I am. We are joined this morning by Nick Muir, Managing Partner from MGR Weston Kay, Anette, who is also from MGR, and William, who is Head of Corporate at Glaisyers. As I said this morning, they'll be talking about investment into the UK after the 31st of December this year. I will pass over to Nick, and he will start with the Brexit journey.
Good morning, everyone. Although today is very much about doing business and looking forward, I don't think any discussion on Brexit would be complete without a discussion about, or confronting the elephant in the room, which is the complete mess, I suppose, that Britain finds itself as a result of the Brexit process. So before we get into the actual doing business in the UK, we thought it'd be useful if we provided a brief outline of why Brexit took place, what's happened to date, what still needs to be resolved, which is a lot, before our transition period ends. Because I think it's important to do that, to set the scene, because we have a new relationship which is meant to start in 2021, 1st of January, and we find ourselves with a lot of uncertainty. So, I suppose the first question, or the first question to ask is, why did Brexit happen? And I think to look at this, so it's important to go back as far as 1997, when we had a Labour government came into power under Tony Blair, and they made the decision not to join the single currency union, the euro. Gordon Brown, the Chancellor at the time, was rather concerned about the union. Tony Blair, less so about the monetary aspects, more about the political will within the UK, the sense that British people would not react well to what they perceived to be a loss of sovereignty. So Britain did not join the euro, and I think that's the starting point of a certain divergence between Britain and the rest of the European Union. So things continued for about for another 13 years, and Labour stayed in power until 2010. The Conservatives came to power under David Cameron, and it's important to note that David Cameron was very and is a great advocate of the European Union, pro-European Union. But unfortunately, at the time, he was facing a lot of political pressure from within his party, factions who were less favourable towards the European Union, and outside his party, namely the rise of the UKIP party, Nigel Farage. You may have heard of Nigel Farage. So he decided that he needed to, as we say in the UK, lance the boil, confront the issue, and during the 2015 election made a pledge to the British people that if re-elected, which he was, he would seek to renegotiate the terms of Britain's membership of the European Union and come back and put that to a referendum. As I say, he won the general election, and the referendum, he went to Europe, renegotiated a settlement, which I think, looking back, wasn't too much. There wasn't too much ground given up by the European Union, and put that to a referendum. As we all know, in June 2016, there was a Remain side and a Leave side. I think it's fair to say the Remain side didn't really connect with the British people. Rightly or wrongly, the Leave side campaigned more on emotive issues such as immigration, the loss of sovereignty point, and also the cost of membership. And it seemed to strike a chord with the British electorate. And we now know that on the 23rd of June 2016, the British people delivered a 52% to 48% vote in favour of leaving the European Union. And I think it's fair to say that's when the real fun began. So what happened next? Well, Brexit Part 1. In terms of what happened next, David Cameron resigned immediately, having campaigned for remaining in European Union, he felt that he could not go and negotiate for Britain to leave. So that was the first problem in this journey. What happened next was Theresa May, who you'll all know, became leader of the Conservative Party. Didn't go to the electorate. She was appointed leader of the Conservative Party, and she became Prime Minister. She triggered Article 50. Article 50 is our formal divorce notice. I suppose it's like serving papers on your wife, or if you have to do that. I haven't, thankfully. But it's a formal divorce notice in March 2017, setting an exit date of the 29th of March 2019, and that was to leave the EU with or without a deal. Committed to this concept of Brexit means Brexit, whatever that means, but she was really hampered by, again, factions within her party and outside her party who were very favourable, well, they took more of a Remain position and were looking for a settlement which was closer to Europe. And this became a theme of her premiership. And I think, again, what she sought to do was get a mandate from the British people in order to tell Parliament that the British people have given me the power to negotiate the settlement that I want to negotiate. So she went for an election, and it was a big political misjudgment. She lost what was a slim majority and only held a minority, and was only able to form a government with the help of a very small party in Northern Ireland called the DUP. So going from a position where she had some strength, she was further weakened. And I think the Parliament census, so we entered a long period now where Parliament really held the upper hand, so much so that in June 2018, the House of Commons, our Parliament, passed the EU withdrawal bill, but put a very important clause in there which shifted the balance of power significantly. And that clause was that Parliament had to vote on the terms of the final withdrawal deal. So Theresa May at that point was well and truly snookered. She tried to put deals to Parliament, but they were voted down with historic majorities, so huge numbers of MPs voting against her proposals, including one on the 29th of March 2019, which was a date on which Britain should have left the European Union. She did manage to negotiate an extension for leaving the European Union, which was 31st of October. But I think by then, by May 2019, it was clear in her mind that she could not deliver Brexit. So we had the second casualty of the Brexit process, and Theresa May resigned. Meaning that the Conservative Party were looking for a new leader, and they appointed this chap here, Boris Johnson, who you will probably recognise, our Boris. Again, he wasn't elected by the electorate. The Conservative Party in the UK, the party that's in power, appoints a leader, and that leader becomes Prime Minister. So he was appointed successor eventually in July 2019, and he set about renegotiating, or he said renegotiating, our Brexit deal. As it turned out, it was just a modified version of Theresa May's deal. Included a Northern Ireland protocol and dealt with the UK leaving the customs union. But like Theresa May, he was faced with a parliament that really was not on board with what was being proposed. And there was a big stalemate and a lot of issues around Parliament and the operation of our Parliament around that time. What Boris Johnson was able to do, he was able to negotiate a further extension to 31st of January 2020 and was able to call an election. Calling an election was not easy, but he managed to call an election. And that was his opportunity to go to the British people and say, or as he put it, do you back me? And as it turned out, or obviously a general election is fought on lots of issues, but the Conservative Party, led by Boris Johnson, won a landslide victory. So Boris Johnson was able to turn to Parliament and say, I have the backing of the British people, you should vote with what I propose. So duly, on the 29th of January 2020, his Brexit deal was passed by Parliament, and at 11 p.m. on the 31st of January 2020, Britain left the European Union. And it's important to note that Britain did leave the European Union on the 31st of January 2020. What we are in now is a transition period to the end of this year. Okay, so our new relationship with the European Union does not commence until next year, 1st of January 2021. But that leaves us with a lot to resolve, seeing as very little has been resolved in the last 10 or so months in terms of where we got up to now. So what the withdrawal agreement did deal with was how the transition period should work, and that's what we are in at the moment. It also dealt with cross-border or how goods or checks on goods between Northern Ireland and the Republic of Ireland. Remember, the Republic of Ireland remains part of the European Union. It's not part of the UK. The UK's financial settlement is dealt with, but what is left to deal with, and where we are at the moment, is a negotiation on the new terms in terms of a new relationship, including our trade and business issues, fishing rights yet to remain resolved, and other regulation issues such as medicine and security. So that's where we are. A lot of negotiations to be done. We have 65 days until the end of the transition period. I understand there's no prospect of the transition period being extended, no scope for that whatsoever. In terms of what's at stake, I'm told it's 900 billion euros of annual trade is at stake, and the 4 sticking points at the moment are level playing field. The European Union would say that they have offered Britain a very generous tariff-free, quota-free trade deal. In return, they would like a commitment from Britain that we're not going to use state subsidies unreasonably or ditch environmental legislation. They want a level playing field. Fishing rights seems to be a sticking point. My understanding, that's more about posturing and gesturing. That there is a deal to be done on fishing rights, but that is something which publicly needs to be resolved. And when I say fishing rights, I mean Britain is looking to take back control of its territorial water and the fishing rights within that. The Northern Ireland Protocol, now this is interesting, that will take effect on 1st of January 2021. It's very important that there's a free movement of goods between Northern Ireland and Republic of Ireland, minimal or no border checks for political reasons as much as anything else. A slight disruption to that occurred recently when in September 2020, last month, Parliament passed what's called an internal markets bill. And from the EU's perspective, that's a worrying development, because Britain, having passed that bill, Britain can now go back on what's been previously agreed. The EU are not happy with that and are taking the UK to court. So not very good at the moment when we're trying to strike a deal being taken to court by the EU. And the 4th area that needs resolution is we need a system to resolve disputes, such as the internal market bill. So, as I say, less than 65 days, a lot of posturing on both sides and a lot to be resolved. But both sides are negotiating. We recently passed a summit, nothing came out of that, but negotiations are continuing. It's felt that mid-November would be the cut-off point. There is no opportunity to extend the transition period, so mid-October is the cut-off point for reaching agreement. Although other commentators will say negotiations will continue right up until midnight on the 31st. But we shall, I think realistically, things have to start taking shape very soon. I think what some people are suggesting is that Boris Johnson is looking towards the United States at the moment, and the election that's going to take place on November the 4th there, I think it's the 4th. The feeling is that if Trump stays in power, Boris will feel a little bit more empowered, knowing that he can go to Trump and probably strike a UK-US free trade agreement quite quickly, which he can then either feel more comfortable and relaxed that that's in the bag, and then possibly strike a more forceful deal with the European Union, or ultimately leave on what we call a no-deal basis. On the other hand, if Biden wins, he might not have that feeling of security and power. So it's interesting that the US election might be a factor here. So a lot still to be decided, and it seems, from a process that started so many years ago, we are really going right to the wire. But having said that, although there's a lot of uncertainty still around how Britain's future relationship in 2021 and beyond will look, I think it's important to note that there are some constants, a lot of things that will not change. And historically, the UK has been we feel, a very good place to do business. And we think that a lot of the factors that contribute to that will remain constant. Not everything's going to change overnight. So before I hand over, well, the last section of this presentation is going to be taken by Anette, who will give you some heads up on some important planning, things that we know will change and things that you and your clients should be thinking about if they're doing business in the UK. But first of all, I think let's set the scene in terms of an overview of doing business in the UK. So, okay, right. So this is an overview I've taken this data from the World Bank. They carry out a survey every year where they survey all the economies in the world and rank them in terms of ease of doing business. And the UK has consistently, I've been looking at these rankings for many, many years now, the UK consistently ranks in the top 10 in terms of ease of doing business. So in the latest survey, which I think is the 2019, or this might be the 2020 survey, Britain is still ranked number 8 in the world in terms of ease of doing business. And importantly, we are one of the highest placed European nations. Denmark is placed above us, but you'll see all the other jurisdictions, territories are outside Europe. Norway is below us. The survey looks at a wide range of measures. And you can see that, for example, we're only 27th in the world in terms of paying taxes, but it's reassuring that in terms of getting electricity, we're number 8. So we've got a good electricity supply, although I understand that's possibly because we purchase a lot of electricity from France. I don't know. But we have a good electricity supply, but a good place to do business, and we think that will continue. So Britain, or the UK, is comprised of 4 nations. It's England, Scotland, Wales and Northern Ireland. We have one currency, not the euro. We have our GBP. We have one principal government based in London, but we have devolved powers to regional government, or to the assemblies of Scotland, Wales and Northern Ireland. These are relatively new devolved powers, certainly for Scotland and Wales. But most of the power still rests with the House with Westminster in London. In itself, the UK is a big market, irrespective of its international outlook, and I'll touch upon that briefly. We have a population of 67 million, so a big market. We have a GDP in 2019 of 2.21 trillion, placing us 6th in the world, and we do sit on the G7. Generally, I think it's fair to say that we have a internationally recognised business culture. Our language is obviously widely used throughout the world. I think we have we have a high-skilled workforce, international workforce as well, and I'd hope that that would continue. And I think there is obviously that should be respected going forward. We have we have good transport infrastructure, whether that's international, for example, Heathrow in London is a major international hub, and we have good internal transport links. So it is not a bad place to do business. What we're going to do now is just go into a little bit more around the legal framework in the UK, and then I'm going to come back and talk a little bit, give an overview of taxation in the UK and some of the financial reporting aspects. So I think at this point, unless correct me if I'm wrong, I'm going to hand over to William from Glaisyers, who's going to take you through, shall we say, a legal overview of the UK.
Yes, thanks very much, Nick. Yes, it's William Pinnock from Glaisyers here. For those of you who don't know, Glaisyers Solicitors means Glaisyers lawyers. We're lawyers, and we're described in the UK as solicitors. Thanks very much for that review of the Brexit process, Nick. That's sort of brought back all the pain and embarrassment I felt over the last 4 years. But we are where we are, so we should move on. So picking up on where Nick described the makeup of the UK, we have the four parts of the UK. These are actually subject to different jurisdictions. For historical reasons, England and Wales have the same legal jurisdiction. Scotland is distinct. Northern Ireland is also distinct, although I think it's fair to say that the differences between Northern Irish law and the law in England and Wales is comparatively minor. Having said that there are different jurisdictions, all of those jurisdictions will certainly on the surface appear quite similar. All recent legislation, particularly EU legislation, applies equally across those jurisdictions. And therefore the differences are probably not so great as to affect your decision as to whether to establish an operation in England, Wales, Scotland or Northern Ireland. As Nick commented, there are fairly recent parliaments or assemblies in each of the other jurisdictions. I mean, I've used the word that they can tweak the law there. That's probably a word which certainly the Scottish Parliament, I'm sure, would be very unhappy to see. Of those parliaments assemblies, certainly the Scottish Parliament has more powers than the others. It includes some ability to change its tax regime. I think it's fair to say that all the jurisdictions offer a mature legal environment. It's a stable and responsible environment in which to do business. Property rights are respected. There are well-established procedures. There are well-established lawyers to enforce rights. So I don't think there is any preference of the legal systems between the different areas. The laws are enforced through systems of courts. What I've summarised there is what applies in England and Wales. System of county courts for the more smaller cases, high courts, Court of Appeal and Supreme Court. Of course, until the end of this year, there is also the Court of Justice of the European Union, which has jurisdiction and may have some probably limited jurisdiction in the future. There are also some specialist courts. So the message overall is that there's a sophisticated system in which you can do business, enforce and protect your rights. So the decision to be made if you choose to invest into the UK, the first decision to make is whether you wish to establish a branch or establish a subsidiary. The difference between these two are that if you establish a branch, your home or your parent entity merely starts trading in the UK without establishing a separate legal entity. So as the slide here says, it's very similar to starting up a new location within your home jurisdiction. By contrast, establishing a subsidiary means creating a legal entity within the UK, which will have its own rights, liabilities. It will have to be established in accordance with the laws of the UK. All the operations within the UK, of course, will always be subject to the local laws, with slight exceptions, one of which is identified here. A branch has to file in the UK a copy of its parent accounts, that's to say, the accounts of the entity in the home jurisdiction, whereas a subsidiary will file its own accounts, which will only disclose its own operations, assets and liabilities. There are differences in the taxation of a subsidiary or a branch, which I think Nick will pick up on later on. Probably the most important difference between a branch and a subsidiary, however, is that a subsidiary ring fences its own liabilities, meaning that if you establish a subsidiary in the UK and for whatever reason it gets into difficulties and incurs significant liabilities, it owes money, say, to a number of creditors in the UK, those creditors can only enforce against the subsidiary. They cannot proceed against the parent company in the home jurisdiction. So, using a branch means that the parent entity establishes its operations in the UK without using a separate entity. So in my example, I've anticipated we have a French company, Franceco SA. It can take premises in the UK, it can employ people, and in those relationships, it will take part directly itself. So when it takes a lease, it will be the tenant of the property, and the French company itself will be the tenant. In relation to the employment contracts, it will be the employer. So if any liabilities to the employees arises, a claim would be made direct against the French company. And it is trading, it can enter into supply agreements and sell its products and services. The rights and liabilities are owned by and bind the French company directly. It is by default, the branch would contract with employees, with its landlord, with its counterparties under the local law. So that would be typically England and Wales, or possibly Scottish or Northern Irish. It is possible for parties to an agreement to specify that the agreement is governed by foreign law. For example, in this example, French law. That would be very unusual. It is possible, it does happen. Rights can be enforced, but that would be very unusual. And then, as I said on the previous slide, by using a branch, the parent company does not ring fence the liabilities of the UK operation. So if the UK operation incurs a debt, the creditor can pursue the parent directly. And the likely route would probably be an action within the UK, leading to a judgment. And then it can proceed to try and enforce that judgment first against the French company's assets in the UK. And if those are insufficient to satisfy the judgment, it can pursue the French company's assets in France, subject to the rules on enforcement of foreign judgments. But the right to pursue those assets in France exists. Moving on to the next slide. By contrast, using a subsidiary, it's a separate legal entity. So in my example, Franceco SA would establish a UK subsidiary, possibly titled Franceco UK Limited, incorporated in my example in England and Wales. That entity will contract with suppliers, employees, its landlord, etc., on its own behalf. Almost certainly it would have limited liability, which is a very important concept, which ring fences its liabilities in the subsidiary and doesn't allow a creditor to proceed against the parent. There is a wide range of different entities which are available. However, in almost all situations, certainly for a European parent company wishing to establish a new company within the UK, a limited company limited by shares is almost certainly the most suitable entity. We have another entity called the Limited Liability Partnership, which possibly is of interest. It shares the advantages of limited liability with a limited company, but it's tax transparent. So it is not subject to tax. Its profits are taxed in the hands of its members, and all the reliefs which would normally be available from tax would be available to those members of the LLP. That, as you can imagine, it would be of interest in some situations. Finally, just to mention another aspect of using a subsidiary is a presentational advantage. For good reasons or bad reasons, counterparties who, let's say, are UK counterparties probably find it easier to deal with a UK company rather than a French company. that there is some sense in that, in as far as it's an entity which they're familiar with. If you look at it a little deeper, you might correctly say it doesn't really make sense, because the UK company may be a man of straw, meaning it has no real value, whereas the parent company could easily be very substantial and have significant assets, which would actually provide much more reassurance and certainty of payment to the counterparty. But nonetheless, I think it's probably the case that certainly some people in the UK would prefer to deal with a UK company. So limited companies, a little bit of information about them. As I say, it's a almost universally used entity within the UK. They can be set up fairly cheaply. If you take a very simple limited company, it can be very cheap indeed. If you wish to customize its powers or its structure, obviously it becomes a little more expensive. We've mentioned limited liability, so its liabilities are ring-fenced. The owner of the company isn't liable for its liabilities. By default, it has no limits on its powers, so anything which an individual can do, it can do. It is a very flexible form. There are very well established structures of a limited company, but it can also be customized in a very wide range of ways to accommodate shared ownership with differential control, different funding, different extraction of profit. Perhaps an example to think of, when Mr. Rolls and Mr. Royce first met, Mr. Rolls had lots of money and Mr. Royce was a very clever engineer. How did you accommodate their contributions and the rewards which they would get out of their company? I admit that I've used that example partly because they met here in Manchester in a hotel, which is about 200 yards away from where I'm sitting at the moment. But you appreciate that the general point is that different participators in a company might bring very different things to it and might be expecting different kinds of rewards from it. And a limited company can accommodate a wide range of different situations of that sort. Briefly, the structure of a limited company is two-tier. So that's to say there are the shareholders, who are sometimes called members, but their real status is they are the owners of the company. And then there are directors. I'm aware that I think in some European companies, you have a three-tier structure of an operational board and a supervisory board. We don't have this in a limited company. Those two aspects are both incorporated into the board of directors. Shares in company can be publicly traded. There are a lot of additional rules governing that. A slight point of warning, limited companies are subject to a concept called maintenance of capital. I think it's probably fair to say that this is of historical importance only now. Originally, when companies were provided, the idea was that there would be a fixed sum of money which would be available to pay creditors. The reality of that protection, I think, has largely disappeared now. But I think it probably is worth mentioning that it can make it difficult to extract value from companies. Doesn't make it impossible, it just makes the extraction of money subject to some additional procedures.
Yeah.
And finally, there is a substantial mergers and acquisitions industry in the UK dealing with the funding of and trading in companies and businesses. So it's a very well established entity, and transactions involving companies are well known, and there are many people who can contribute to that. Regulatory issues on doing business. I think it's probably fair to say that the UK is probably less regulated than most European jurisdictions, but there are a lot of common features. And of course, with countries in the EU, a lot of the rules which govern operations in the UK are derived from the same EU rules. So, for example, these would apply in employment, environmental protection, health and safety, data protection, in all of those areas. The legislation which applies in the UK has been driven for the last 20 years or so by EU legislation, and therefore it is likely that even if expressed differently, the fundamental protections and rules which are in place are probably similar to those which you're subject to in other EU jurisdictions. Otherwise, there's regulation of different sorts applying to different business areas. Clearly, some areas are high risk, and there are other areas where there have been there's been a history of conduct which is deemed to be unacceptable. I suppose the obvious example here is financial services, which I think probably quite properly is now highly regulated. In other areas, there are the professions which are regulated in the way which you would expect: doctors, lawyers, accountants, architects, pharmacies, insurance, all have their own levels of regulation which you would expect. And then there are the areas which, again, are driven by the rules of the EU, which cover competition, procurement, and state aid. Again, the rules in the UK will be driven by the common EU standards, which will apply to operations across Europe. And I think at this stage, where the word tax appears, I think it's probably time for me to pass back to Nick to take you through those aspects.
Thank you, William. So I'm just going to spend a few minutes now just giving you an overview of taxation and also the financial reporting framework in the UK. And as I said, then I'll pass on to Annette, because that's an incredibly important session. Annette's going to run through some important steps that should be taken, or we can be taken, in respect of businesses doing business in the UK, based on what we know is all happening. But in terms of profits, taxation of profits, we have corporation tax in the UK. It's due on taxable profit, not accounting profit. So you'll be familiar, I'm sure, with taxation of profits in your own jurisdictions. There are adjustments between accounting profit and taxable profit. But I suppose we have the relative, we have a rate of 19% across the board. So there is no differential between large and small companies at the moment, and no banding. So 19% is our, as I say, a one-size-fits-all rate, which I think is competitive internationally. There are some differences, and William alluded to this earlier. There are some differences between the treatment of how that corporation tax is applied to branches and subsidiaries. And broadly speaking, a subsidiary pays corporation tax on its worldwide profits, whereas looking at a branch, the corporation tax will be due on its share of attributable profits in the UK. A branch can also automatically transfer losses, where in the UK that there are certain restrictions, or quite a lot of restrictions, about transferring losses to fellow group companies. So at a high level, those will be the two big differences between a taxation of profits between a branch and I've assumed a limited company here, although, as William said, there are other options. But in terms of what we most commonly see, it's a limited company. But also, we have a concept of permanent establishment in the UK. So if you have a permanent establishment, or what HMRC, our taxation authorities, deem to be a permanent establishment, you could also be subject to corporation tax on the profits arising in the UK. And I'm just going to try and move on to the next slide here. Yes, I think this concept will be familiar to a lot of you, because I think throughout Europe, permanent establishment is recognised. But a permanent establishment in the UK will arise where there's a fixed place of business in the UK through which the business of an enterprise is carried on, either partly or wholly, or where you have an agent who acts on behalf of the enterprise to conclude contracts, unless that agent can be shown to be acting independently or is of independent status. So We have branches, we have the concept and limited companies, but it's important to bear in mind we also have permanent establishment, and the permanent establishment rules can bring profits into UK corporation tax, or into the scope of UK corporation tax. So that's taxation of profits, very, very simply. In terms of employment taxes, like many other jurisdictions, we have income tax and social security. These are deducted from employees through what we call our PAYE system. It's pay as you earn, and it's the employer's responsibility to account for these taxes, to deduct the amounts due from the employee for income tax and for national insurance, and the employer also has to make social security contributions, national insurance contributions, and again, they have to be paid through the PAYE system. On the slide, I've just given a little bit of detail on national insurance, our social security contributions. Income tax very much depends on taxable income. Not really possible to give a little bit a simple overview, but it is still the employer's responsibility to deduct income tax through PAYE and pay it over to HMRC on a monthly basis. And in terms of administration, I suppose it's important to point out that we have real-time reporting in the UK for PAYE and NIC, which means that when an employee is paid, HMRC are notified and receive details of the payroll run. So we have that joined up reporting, and as I said, PAYE and NIC is due monthly. In recent years, employers have become responsible for making pension provisions for employees. So we have now a system called auto-enrolment. So I think it's fair to say it's a basic minimum pension provision for employees. So most staff will be, most employees will be eligible to join a plan, and an employer must make a plan available. And if an employee opts in, the employer must make contributions as well. And the minimum employer contribution rate at the moment is 3%. I think it's fair to say in the UK, possibly certainly amongst younger people as well, there isn't much of an appetite for making pension contributions. So a lot of the time employers find themselves not making employer contributions because they're not having to match contributions made on the employee side. But we do have that in place. An employer has to make it available to staff. And I think in terms of this overview of employment taxes, it's probably important to point out that we have quite a lot of legislation and rules regarding employee and self-employment status, and these are constantly evolving because as an employer or a business, it will be, or it's generally a lot cheaper to contract with a self-employed person as opposed to an employee, because there's a national insurance or social securities saving immediately. You can see that an employer, if you're not an employer, you don't have to make employer social security contributions. So over a number of years now, I mean, certainly I remember probably going back 20 years now, the rules and legislation have been evolving to stop businesses contracting with contractors, self-employed status people who really, the substance of their relationship is one of employment. So I think that's something that we advise on quite a lot, not just businesses coming into the UK, but businesses from within the UK look up very carefully. It's very important to look at what's actually going on, and have we got what we call a master-servant relationship, which is indicative of an employment situation, or is it a situation where the person that's been hired to do the work has a lot more autonomy, in which case that suggests a self-employed status situation. And it's very important to get that right. VAT, well, what can I say? We still have VAT. We still operate VAT, and we operate VAT as throughout the EU, VAT is operated. What I would say is we have we've had a project over the last few years called Making Tax Digital, which is about the digitalization of reporting to taxation authorities, very much using cloud-based accounting software. The biggest accounting software in the UK is Xero, followed by QuickBooks, both cloud-based, and that facilitates this Making Tax Digital project. I know we're quite a long way behind some other nations in Europe, such as Poland, but we are getting there, which means more real-time reporting to HMRC. And it's probably fair to say that VAT has been where a lot of that development has been driven, and it is that VAT reporting now has to be carried out through in a lot electronic means, which usually means having compatible software or using some kind of bridging, what we call bridging, maybe an Excel-based bridging solution. But VAT has moved that way. Other taxes are likely to follow in the same way, but VAT has been at the vanguard in terms of HMRC's project to digitalise tax. And I've just listed the current rates are of VAT as things stand there, but we have obviously a standard rate, a reduced rate, and a zero rate. In terms of financial reporting, William pretty much covered this off earlier. The difference between a branch and subsidiary is obviously defined with parent company accounts for a branch, and for a subsidiary company, or whether it's an LLP, it will be the accounts of the entity. Just important to note that, and William did mention this, but just say again, the parent company accounts that are filed with a branch are prepared under the parent law. So if it's a French business with a branch in the UK, the accounts will be prepared in accordance with French law and applicable French GAAP. A UK subsidiary, whether it's an LLP or a limited company, the accounts that are filed at Companies House will be under UK GAAP. We have quite generous provisions around small company accounts generally in the UK, which means that most accounts placed on public record with Companies House and available to the public for inspection are actually pretty meaningless for someone looking at the accounts, in that generally most accounts are just filed with a balance sheet and very few supporting disclosure notes. These provisions generally apply to smaller entities, but they are there. They're good for companies, I suppose, frustrating for people wanting to look up and try and understand the activities of a company, but that is relatively attractive. There's quite a low level of disclosure at Companies House for smaller companies. Okay, and just in terms of our overall financial reporting framework, we have various financial reporting standards, but it's important to note that we are, in terms of PLCs are public entities, and are required to report under IFRS EU adopted standards. Having gone through a lot of convergence pain, I can't see us diverging very quickly. So we are IFRS based. We have I would call it a slight offshoot of IFRS called FRS 101, which is a reduced disclosure framework. I won't go into too much detail, but it is very much IFRS based. The major reporting standard in the UK is FRS 102, which the majority of companies will probably report under. Although it isn't IFRS, it is very much fair value accounting based, which means in practice, when we work with, or when we report under FRS 102 upwards for consolidation at IFRS, there are not, the number of adjustments aren't that great because it is fair value based accounting. And we have something called FRS 105, which I'm not going to mention, but other than say it's for very small entities and is not applicable for subsidiaries, but it is there. We generally don't work with it that much. So that's a bit of an overview in terms of tax. It's a bit whistle-stop, very fast, it's high level, but hopefully it's given you an overview of tax and financial reporting. As I said, I think one of the oh, sorry, just before I move on, I've included a slide here which just compares and contrasts branch and subsidiary in terms of tax on profits, loss relief, treatment of liabilities, practicalities, winding up and disclosure. Pretty much all of that we've covered off on the slide so far, but I think it's a useful takeaway and summary. Obviously, if you get asked by a client the key differences between branch and subsidiary, that should be a useful resource. But please, there's no substitute for contacting either ourselves at MGR or Glaisyers, because there's a little bit more to it than here. This is very much an overview and a high-level summary for you. So I think that takes me up to the end of my section. I'd like to hand you over to Anette, who runs our inward investment desk here in London, and she's going to take you through planning for Brexit. I think this is a really useful section. So over to you, Anette.
Thank you, Nick and William. So yeah, we are now talking about what's happening, let's say, after 31st of December, because we are at the moment in the transition period. Yeah, so Brexit we already have, but as I said, we are in the transition period. So with Brexit and what we expect with a no-deal Brexit, UK becomes a third-party country, which means there will be no intra-community supplies anymore. So this means also we will lose a lot of EU simplifications from 1st of January 2021. The movement of goods will be treated as import and export with import VAT and other restrictions, so a lot of paperwork will follow with this. Then we will have that the distance seller threshold in EU member states will no longer exist for UK companies and also not for EU companies importing to the UK. So you really need to check if you are importing under these thresholds, and then there might be action you need to take. The EU mini one-stop shop single VAT return scheme for digital services will no longer be available for companies trading with the UK. Then the EU VAT refund portal, which is used at the moment for UK companies and also when you are in the European Union and you want to get refund from UK VAT, this can't be used any longer. Then the call-off stock simplifications will not be available anymore. We will not have the £15 low-value consignment stock relief available. Northern Ireland will enter into a special VAT and customs relationship with the EU. Nick mentioned this already. And we will have customs duty, which will change. Thank you. Then we will have a look, first of all, on VAT on cross-border goods change. So goods crossing international borders will become imports and exports. This means in the end, import VAT is due. So for businesses importing to the UK government wants to introduce a postponed accounting with VAT deferral scheme, which will be available until end of June next year, so that you will not have to pay cash at the border, so you don't have to pay cash at the border. Then for goods up to £135, the seller or their postal service provider has to declare and pay import tax to HMRC on a quarterly basis. So VAT is then charged at a point of sale. UK businesses with a foreign VAT registration in the EU may now be obliged to appoint a VAT fiscal representative in this EU state. So we don't have this in the UK. You don't need a VAT fiscal representative in the UK when you're VAT registered. However, as Nick already mentioned, we have Making Tax Digital in the UK, so your VAT return needs to be submitted digitally. There are different ways. I don't want to go into detail here, but you should be aware of this. Intrastat still needs to be filed for companies delivering to the UK, but not for UK companies selling goods to the European Union. So this will change from the 1st of January. When you are doing business-to-business triangulation and commissioner simplifications, then this need to be reviewed. So you really need to contact your accountant or ask us for help, because you might need a VAT registration in the UK or in another EU member state. So the steps you need to take is, first of all, you need to apply for an EORI number in the UK. So even if you have an EORI number in a EU member state, this doesn't help. So if you want to import goods from 1st of January, you need an EORI number in the UK. Otherwise, you can't bring your goods into the UK. You might need a VAT registration either in the UK, so when you're bringing goods to the UK, or if you're delivering goods to EU member states, since the distance seller thresholds are no longer available, you might need a VAT registration in one of the other or in more than one of the EU member states. You definitely need to decide which customs agent you want to use to send goods to the UK and from the UK to other EU member states, because there is action which needs to be taken, and this needs to be done as soon as possible. If you want to use the transitional simplified procedure or the duty deferment account, you need to apply for this. If you want to pay import tax on a monthly basis rather than as soon as the goods enter the UK. For exporting of goods, you need to check if you need an export license. So if you are a UK company and you are exporting goods to European Union, you really need to check if there's the obligation of having an export license. Then you also need to check if your IT systems are supporting you so that you can run invoices from 1st of January with the right VAT rates, that the terms and conditions are right, that everything is put in place. So, one sentence on cross-border services. As of now, we don't know anything about any changes, so hopefully this will stay as it is. So Brexit shouldn't have any impact on this, but no guarantee here. It's just where we are at the moment. Other tax changes, so we don't know anything about changes of the VAT rates Nick already mentioned. We haven't heard anything that corporation tax will change after Brexit, and we don't know anything that transfer pricing will change. However, transfer pricing you should really discuss with your accountant or with us if there's anything you should need to do. So, and then I hand over to William for our last slide. What else will change with Brexit in the UK?
Thank you, Annette. Just quite briefly, will there be changes to the general landscape for doing business within the UK following Brexit? Well, in due course, yes, almost certainly there will. Immediately following the end of the transition period, not much. The basic legal entities which are available now will still be available, possibly with the exception of the one I've highlighted there, the European company. Very little used in the UK, so unlikely to have much impact. The basic legal environment of contract law will be unaffected. There are lots of more specialized areas where recent developments have been heavily driven by EU regulations, or which I touched on earlier. These will not be affected immediately, either because they've already been incorporated into UK law, or one of the provisions of the withdrawal agreement will specifically make them apply in UK law immediately following the end of the transition period. So I've listed the obvious candidates there: employment, environment, health and safety, data protection, financial services. So there'll be no immediate change. It is likely that in due course there will be changes, obviously driven by the government of the day. in relation to employment, I mean, that's politically contentious, so we can certainly expect changes there. Environmental protection, less so. Health and safety, less so. Data protection, again, it's not really a political issue. I think we'll certainly be wanting to have, I think it's described as adequacy status in relation to the EU, for which we have applied, meaning that we're a jurisdiction in which we have adequate data protection provisions in place. There are certain areas where where change is more likely and is likely to come sooner. I've mentioned them there. Competition, particularly procurement and state aid. I mean, this links back to one of the aspects which Nick mentioned at the beginning, the insistence by the EU, reasonably, in my view, that we provide a level playing field for companies operating here and in Europe. So the overall message is, will there be changes? Yes. Will they be happening immediately upon 1st of January 2021? No.
Well, that brings us to the end of our slides. I just wanted to point out again that if any of you do have questions following on from the presentation today, please feel free to email them to me or any one of our speakers, and we'll do our best to answer them. I will share the following slide with you as well. Here's the contact information for each one of our speakers. We thank you for your time. We hope that you've learned something this morning and appreciate you joining us. Have a great rest of your week, and hopefully we'll see everyone soon. Thank you.
Thank you. Bye.
Thank you.